Can you hear me, Judge?
I hear you.
Okay, appreciate it.
All right. This is the matter of Mariah Takia Dorsey, represented by Mr. Joseph Todd, and the state represented by Mr. Steve White, practicing under the, what is it? They used to call it the Third Year Practice Act, but he's being supervised by attorneys for the Solicitor General's office. And Mr. White is present with witnesses for the state. This is a motion to revoke bond.
Your paperwork.
All right. All right. So, Mr. White, are you ready to go forward with the hearing?
Yes, Your Honor.
Mr. Todd, ready to go forward with the hearing?
Your Honor.
Okay, Mr. White, you may begin. Did you need an opening or did you wish to call your first witness?
Judge, we'd like to invoke the rule of sequestration.
All right, so Mr. White, Mr. Todd has invoked the rule of sequestration. So any witness who is not about to testify needs to exit the room.
So he stays with me.
All right. Mr. White, who do you have with you?
Your Honor, the state calls Aaron Jimenez.
All right. Can you, Mr. Jimenez, raise your right hand for me. You solemnly swear or affirm any testimony that you give in this matter will be true. And this is testimony in the case 2021 CR 06164. Mr. White, your witness.
Mr. Jimenez, please introduce yourself to the court.
Hi, I'm Aaron Jimenez. I know her from her being mother of.
Let's back up a little bit. Well, let's introduce yourself. How old are you?
I'm 24 years old.
Okay. And how do you know Miss Dorsey?
She is the mother of my child.
Okay. And
He needs find my files. I don't know where they are.
Go ahead.
okay. Why did you call the police on June 29th of 2022?
I called the police because she was making more or less slight threats that were out of the normal. As she does usually just text my mother. So she reached out to me making threats of coming to get him. And was very, it was out of the normal because she doesn't usually message me. She usually messages my mom.
Okay, so I just want you to clear it up for me a little bit. So let's break it down. So you said earlier that you and the defendant have a child, correct?
Correct.
And why does she contact your mother?
She contacted us because that is our kind of our mediator between where we can drop off the kid and pick him up and whatnot.
Okay, so has she ever contacted you before you felt threatened?
Not really. She does contact me a lot. She does make disrespectful comments a lot, but it wasn't more or less threatening as in what was happening in the text messages.
So why is it then, because she had contacted you before, that you decided to call the police on June the 29th?
Because there were pretty vivid threats, and there was a time limit within those threats.
Okay. And would you recognize a copy of these messages she sent to you if you saw them today?
Yes, I would.
Can you take a look at that for me? Mr. Jimenez, after you review that, what did I just show you?
You show me messages of her threatening and asking for money and there's a lot of talking.
Objection, he's going into the contents of the documents before they've been introduced into evidence. So we'd object to any testimony in reference to that unless the proper foundation is laid.
Mr. White?
Your Honor, we're not using these to show the truth of the matter asserted in the documents. We're using these to show that
I
she
get
made
it, Mr.
contact.
White, but your witness needs to understand that the evidence hasn't been entered yet. He's not to testify as to what is contained in the evidence, but how he recognizes.
Okay. Thank you, Your Honor. Mr. Vance, how do you recognize these documents?
I recognize them from my phone as they were sent to me on those current dates that are on those documents.
And to your knowledge, has any of these been altered in any way?
No,
And these are true of what she sent to you?
correct.
Your Honor, the witness has now verified that this is what she sent her and has not been altered in any way. The state now moves to enter this as an exhibit.
Yeah, we object. First of all, there's not been a proper foundation laid. He's just testified. He hasn't laid the foundation. I don't want to give him the information to lay it, but he has not laid the foundation in order to get those documents introduced into evidence. So he's not done the necessary requirements, the foundational requirements in order to do so.
Your Honor, may I reply to that?
May.
We've already established before I tried to introduce this, that she sent him messages, that these messages were threatening. Then he verified that he recognized them. Then he verified that they had not been altered or changed in any way to his knowledge as they were sent to him. That is laid a proper foundation for these to come in, Your Honor.
Judge, he hasn't laid the foundation. First of all, he's making an assumption. The guy started testifying from documents that had not been introduced into evidence. So that testimony regarding those documents was not, he was testifying even before they were introduced into evidence, number one.
Your Honor, I'm going to have to
Hold on,
interject here.
Hold on.
What?
Mr. Todd, I'm the trier of fact in this motion, so it's minimal. I know what to listen to and what not to listen to. The objection was timely, and Mr. White has instructed his witness as to how he is to identify the document and not go into the content until such time as it has been admitted. So Mr. White has laid a proper foundation. The court will admit the evidence over objection.
Judge May, I understand the court's ruling. I would ask the court to allow me to respond to that. In order to, yes, Judge, in order to have those documents introduced, he has to lay the foundation. I'll give you an example. He hasn't testified as to where it came from. In other words, by telephone number, by the URL, by some means of identification. He's not done that. So
Your Honor, I may
just
have to interject here.
Mr. White, you can't interject. You wait until Mr. Todd is finished and then you
Yes, Your
can
Honor.
respond or make
I
your.
apologize.
Okay,
Judge, there's a proper procedure in order to introduce those documents. In order to, he has to authenticate them. He has to testify as to where they came from. How? In other words, by phone number, by if it's a internet, you know, what the internet address is. There has to be something more than just says that's from somebody. So he has not laid the foundation at this point, Judge. He's not identified them properly and introduced them properly by, you know, setting the foundation to, so we can know that these documents came from whoever he's testifying. You just can't say they came from Joe Blow without something more than that. That's all he said.
okay.
Your Honor, may I respond?
Go ahead, Mr. White.
Mr. Jimenez earlier said that this was sent to his phone. I don't know if the opposing counsel heard that statement, but Mr. Jimenez indeed said where they came from and how he received it.
Okay, the court is satisfied that Mr. Jimenez did state that he had received text messages and that he had received them from the defendant. So the court is satisfied that a proper foundation has been laid. Over the objection of the defendant's counsel, court is going to admit Exhibit 1 for the state.
Ms. Jimenez, can you take a look at these again for me? And could you tell me the date of which she sent these to you?
From the 27th through the 29th.
And where in these messages did you feel threatened?
First section where she was.
You can read it if you need to.
Yes, but there was more to it. Basically, when she said I got 3 days, she just said I had 3 days, and I'm not too sure what she was talking about. Then she went more into the depth of where she described my girlfriend's house, knowing where she lived, and describing the bedroom as well as if she was in the room. She continued to say that she was going to, if she seen me on the street or seen me somewhere, that there would be an issue and there would be a problem, that she would act upon in doing so. And that's more or less kind of where it was for me threatening. Other than that, it was more or less just a lot of sexual talk.
Okay.
So, Mr. White, Mr. Jimenez, the court has to make a decision about whether I'm going to take away somebody's freedom. And so I can't entertain more or less. I have to have, this was threatening. This was exactly what she said. I can't do
Yes.
I just and all of that. If it says it in the text message, then I need to know exactly what it says, because
Yes, Your Honor.
you're asking me to take away somebody's freedom.
Yes, Your Honor. Could you read verbatim of where she threatened you and why you felt threatened?
She responded saying, quote, "You have 3 days." Let me find some more quotes. She said, no.
Okay, let me ask this, Mr. White. Was there a bond condition in this case?
Yes, Your Honor. The bond condition was there to be no contact with Mr. Jimenez.
Do you have the bond from?
Yes, Your
Magic-
Honor.
Okay. Can you share that with the court?
Yes, Your Honor. Your Honor, do you want me to show it to you? Or do you want me to just read it to you?
Can you show it to me?
Yeah.
Okay, so the court sees the bond condition, which court recalls as a document prepared by magistrate court judges at first appearance. I see that the name Aaron Jimenez is in the area where it says that the person is to stay away from that person. Absolutely. And there's also an address located in Hampton, Georgia. All right. So as I said, if we're talking about threats, then they need to be specific. Mr. White, you may continue with your witness.
Yes. So,
You use it back home?
no, we see the documents. Okay. First, I want to establish, how did you know that the defendant sent these to you?
She started off by saying, "Come get your love child," which would mean my son, and the only person that has my son would be her.
Okay. And then Where did you feel threatened exactly in these messages?
Felt threatened when she said I got 3 days.
Okay, so you got 3 days. And earlier you said you also felt threatened because she knew about your girlfriend and her living situation. Can you point that out to me also?
Yes.
And just read it verbatim.
She said, I'll just read the whole thing.
Yeah, go ahead.
The one that don't got to Photoshop all her pictures and use her card to cop N-word, because her stomach claps with her P, her private part, pitty flat, like pancakes, stay in a one-story house. I'm the only girl you give money to, and nutted in 5 years and cried.
Okay.
Sorry.
No, that's completely fine. So she told you she knew where your girlfriend stayed, and she told you that you have 3 days. Mr. Jimenez, tell me what happened 3 days later.
My car was vandalized, as well as my girlfriend's car was vandalized.
Can you tell the court what happened to your car?
My car front lights were hidden. My driver's side mirror was bashed over. My gas tank was pried open, as it's not a push gas tank. You have to press a button and inside the car to open it. So it was pried open. Gas, there was Diet Coke or Coke, Pepsi in the gas tank, as well as for her car, it was just open with the Coke or Diet Pepsi, whatever, in her gas can. But mine had the most damage.
Okay, and just to walk me through it, so your car was damaged, your girlfriend's car was damaged. What was the parking like? Or is it just the two of you parked there?
No, there was about 5 to 6 cars, as well as no windows were broken. So no one stole anything. There was 5 cars on the driveway. Only both of ours were touched after being told where we stay, being threatened, as well as she knew where she stayed, so we knew that she knew where she stayed at, so she was able to. Yeah.
So let me try and break this down and clarify. Your car was at your girlfriend's house.
Correct.
There were multiple cars there, correct?
Yes.
And none of the other cars besides you and your girlfriend's cars was touched, correct?
Correct.
Okay. Mr. Jimenez, what else has she done to make you feel threatened?
She reaches out to family, friends. She took out a life insurance policy against me.
Judge, I'm going to
Hold on.
Judge, I'm going to interpose. The first objection is hearsay, talking about other people.
Yeah.
Number one. Number two, I don't know what he's talking about as far as an insurance policy, but that would be number one, irrelevant. Number two, the highest and best evidence would be the insurance policy if he's testifying about something about some insurance policy.
Sustained hearsay.
Yes, Your Honor. I just have one last question for you, Mr. Jimenez. After the defendant was told to stay away from you, has she contacted you more than that one time that you used those messages?
Yes, she has contacted me more than once. Sometimes it won't be as threatening as that per se. It would just be more or less, come get your son, and I would redirect her to contact my mother, as she is our middle ground. So yes, she has contacted me more than just that, but those were, again, with the most threatening recently, and with all that's happened with the threats and some actions, it was a little bit nerve-wracking.
Thank you. Your Honor, may I have a moment to confer with my counsel?
You may.
Thank you, Your Honor.
You want to mute?
Yes, Your Honor, no further questions at this time.
All right, Mr. Todd, cross-examination.
Yes, Your Honor. Mr. Jimenez, isn't it true that you had a child with you and Mrs. Dorsey? Isn't that correct?
Correct.
And you, prior to recently here, you had, most recently after this situation started, you had never legitimized the child prior to this time, correct?
One more time?
Objection, Your Honor,
Yeah,
relevance.
Judge, we're showing motive of the reason why he's testifying. We're going to lay the groundwork to show, Judge, that he, in fact, has made up a lot of this stuff for the purposes of trying to get custody. And I'll lay the groundwork as I proceed forward to show the court what he has done and what has transpired during this period of time to show his motive.
Okay, overruled.
Okay. Mr. Jimenez, isn't it true that you filed this incident, this complaint against my client because you were, at the time, you had not legitimized your child? Isn't that true?
No.
Okay.
I
You
filed
still-
this due to safety.
Okay. You have now filed recently here in the last few months, you filed a petition to legitimize the child. Isn't that true?
Correct.
And you also filed a petition in that legitimation to get custody of the child. Isn't that true?
No, it was 50-50. I think that she denied it, and then we went for full custody due to she didn't want to give me access to my son.
Okay. So you're saying that you filed it because she wouldn't give you access to your son. Isn't it
Correct.
true? Isn't it true that you had not legitimized the child? Isn't that true?
We have. I think we did that yesterday or the day before.
Sir, just answer my question. Yes or no, you can explain it. You had not legitimized this child. Isn't that correct during the time that all this happened?
Objection, Your Honor. Mr. Jimenez was answering the question and explaining it, but the counsel was asking an extremely vague question.
Okay,
I don't-
let me clarify the question. Up until the time where you went to the solicitor's office and let them know that you felt threatened, had you legitimized the child?
No, because the court was delayed for Corona. So we had it like 6 months before that. It got delayed for 6 months. We just had it recently. And yeah, so this was only because of delay, not because it's filed after.
So to answer my question, the child was not legitimized, so you were aware you had no legal rights to the child. You were aware of that, correct?
Okay, yes.
Okay. And you were also aware the fact that Mrs. Dorsey, even though you had no legal rights, she allowed you and your mother to visit with the child. Isn't that true?
No, she would drop us off at random times. So not visit, more or less drop us off so we could see him. Yeah. But we wouldn't visit, more or less go over there. So it wouldn't be more or less going over there for a family.
Sir, you remember we just 2 days ago had a full-blown hearing on your request for legitimation. Do you remember that?
Correct.
You remember testifying, you and your mother testified that Mrs. Dorsey had allowed you to see this child for numerous days, okay, and had brought the child over there.
Correct.
Okay, so she had allowed you to visit with the child even though you had no legal rights to do so. Isn't that true?
I would assume so. I was asking because I'm confused if you're asking if visiting meaning going over there, or if she was coming over here, or if she was dropping the kid off.
Okay, sir, you understand the question. You are able to read and write, are you not?
Correct.
Are you on any drugs today that would prevent you from understanding my question?
No, sir.
Okay, so just 2 days ago, did you not testify in this legitimation case in reference to the visitation? And I'm referring to the fact that the child was allowed to stay at your house with your mother to visit with the child. And when I say visit, to keep the child.
Yes, thank you for being more accurate. I appreciate you. Yes.
So, and that was done on numerous occasions. She allowed you and your mother to see this child, correct?
Correct.
Okay. And also during this period of time, you had indicated you had never indicated to the court in the hearing that we had, you never indicated one time that about this incident that happened now that you're telling us about in June. You never mentioned that previously. Isn't that true?
I did. I didn't mention the details within the context of what was going on, but I did mention it.
Okay. And did you ever testify? With that's being taken down under oath, that hearing, that trial that we just had was taken down under oath. And I'm asking you the question, did you testify at that hearing?
Objection, Your Honor, to relevance about another trial and what he testified to when there is physical evidence of said conversation.
Overruled. Go ahead, Mr.
Sir, just a couple of days ago, when we had that full day hearing in your case, you never once mentioned about now this incident that you're claiming happened on June the 29th of 2022. Isn't that correct?
Again, I didn't say the exact details, but I did say that there was a bond being revoked. Yes.
Okay, you said there was a bond being revoked. You never mentioned at one time.
I think,
sir, excuse me, sir.
Mr. Jimenez, you have to wait. Nobody gets to talk over anybody else.
Yes, ma'am.
It's been a long day and my court reporter is exhausted. So if we gotta have these pauses that I gotta impose, I'll do it. But you cannot talk over Mr. Todd, and Mr. Todd can't talk over you, and Mr. White can't talk over anybody, okay?
Yes, ma'am.
All right.
Sir, my question to you is very simple. You never mentioned in that whole trial about an incident happening on June the 29th, 2022, where you felt threatened or she had sent you any type of threatening email. Isn't that true?
Correct, because these are two different trials. That was a trial for my son. This is a trial for her.
Okay. But you mentioned other things during the case of the trial that we just previously had, that you had problems with my client. You testified about some other issues, correct?
Yes, revolving my son. Yes.
Right. Okay. But you never brought this so-called incident or this situation regarding you felt threatened, correct?
I did feel threatened and did mention that, but yeah, I didn't mention that, so I'm not too sure.
Okay. And now you're saying that you felt threatened because something there's in these emails, I haven't seen them, I haven't been provided to me, but be that as it may, something about 3 days, something about 3 days. Okay. There was no actual threat. There was no actual threat for any type of harm or damage to you at any point. Isn't that true?
There was a lot of evidence of her after her saying 3 days of her when she sees me, there will be issues. There is a lot of evidence regarding that factor.
Okay. Isn't it true that she cut off relationships with you back in January or February of 2021?
I do not recall.
Okay. Do you recall on Mother's Day that you went to her house, Mother's Day being May the 12th, 2021? Of course, you're not supposed to, according to the bond conditions, you're saying that not supposed to have any contact. Isn't it true that you have attempted on numerous occasions to contact Mrs. Dorsey?
Negative. She requested that I give, if we don't give her something, there will be consequences for those days. And I think we have those text messages as well.
Okay. So let me ask you this. Isn't it true that you went to her house on Mother's Day, May the 12th, 2021, to give her flowers?
I did drop them off as they were requested.
Okay. She requested you give her flowers for Mother's Day?
Yes, and I think she requested that for this year as well, but I'm not too sure.
Okay. Now,
Was that, hold on, the Mother's Day flowers, was that this year?
I'm not too sure about this year. I doubt it was this year, but I think it was last year. So.
Okay.
and knowing that you're not supposed to have any contact with her, you went to her house to deliver her Mother's Day flowers. Isn't that true?
Yes, as she requested to possibly get my son. Yes.
Okay. And now you keep saying to get your son. Okay. Now, didn't you just previously testify at the prior hearing that that was when the son was born? Okay. She said to you something about you came to the hospital empty-handed. That was back 2 or 3 years ago. Isn't that true?
You said what about? Say that again. Sorry.
When the child was born.
Uh-huh.
when your child was born, Kingston, you know who I'm referring to?
Correct.
Didn't you testify previously that she told you you came to the hospital empty-handed? That's when she was looking for something?
She did.
All right, it had nothing to do with Mother's Day and presenting her flowers and,
That's a different situation.
okay.
You're talking about hospital visit and then dropping flowers at her doorstep.
That's correct. Two different
Correct.
days, two different times, right?
Yes, which were more the same was exactly the same thing as she was requesting stuff. So if we didn't have stuff, I wouldn't get my son.
Okay. And stuff, when you're referring to stuff, are you saying that she asked you to deliver her flowers for Mother's Day? That's what you're telling us.
I'm telling you that she did ask for flowers on Mother's Day. I'm talking about for the hospital situation. She did ask for stuff. She wanted Pampers, wipes, stuff like that. My mom was already bringing that, but she didn't know that at the time, so she was very upset with me.
Okay. And you never provided any child support for many, many months after this child was born, correct?
The child support I provided was Pampers and diapers and wipes and the date and everything that was in his room that was provided by us.
Right. That was that one-time visit in the hospital.
No, that was multiple visits by my mom because I didn't want to get kicked out and we had to make a schedule to be able to see my son because apparently us together in the room wasn't going to make it. And I couldn't see my son and I wanted to see my son.
Okay. Is that why the police had to escort you out of the hospital when the child was born?
Okay, we're getting a little far afield.
Okay.
So from the date that the bond condition was imposed, who contacted who first? That's what I need to know.
Sir, okay, so the judge is aware of it, you continually contacted my client to get back with her to resume the relationship. Isn't that true?
Negative.
Okay, let's talk about the Mother's Day, the week after, the week of May the 17th. Okay, I'm going to refer to that just shortly before this June. Had you not contacted her on numerous occasions, sent her emails in order that you wanted to get back with her?
I don't use email to contact.
Text messages.
I don't recall sending her anything. I don't think I messaged her in about almost a year now.
Okay.
If not more. And that's due to her messaging me first and trying to redirect her to contact my mother so I'll be able to see my son.
Okay. How about the June the 22nd, 2001? Did you not continue to text her on a regular ongoing basis, telling you that you were sorry for the way you treated her? You wanted her to get back together? Do you recall that?
I do not recall that.
Okay. How about June the 25th, 2021?
I mean, these are kind of old dates, but if you have evidence, I don't know what you're kind of referring to. You're just referring to dates.
I've given you the specific date of June the 25th, 2021.
Right, but I don't know what you're referring to as in what that date is for.
I've asked you, sir, I've asked you to say that during that date and on that date, you continue to text her, to contact her, to get back together.
Objection, Your Honor.
What's the objection, Mr. White?
Your Honor, the opposing counsel is trying to ask Mr. Jimenez about a specific date, and he's given him a response. He doesn't know what he's talking about. Now, if the opposing counsel can refresh his memory, he can do a lot of things.
Mr. White, okay, this is something you'll learn about me. I detest speaking objections. Really, it's either relevance or a badgering, or it's a one word. Give it to me, because by the time
Your Honor, badgering.
You make the objection, I've already thought it through and decided pretty much. So here's the thing. Mr. Todd is entitled to a thorough and sifting cross. I have yet to have Mr. Jimenez actually answer the question. He keeps asking for clarification on the question, but he has yet to answer the question that's being asked. And so, Mr. Todd, ask your question again. Mr. Jimenez, you're not asking questions of Mr. Todd, you're answering the question, okay?
Correct.
If you need clarification of a question, ask, sir, could you clarify for me? I don't know what you're saying.
Okay.
Okay,
Mr. Jimenez, trying to be as very clear and precise. On June the 25th, I'm giving you a date of 2021. Isn't it true that on that date that you continued to text Mrs. Dorsey on numerous occasions requesting that you all get back together?
I don't recall.
Okay, I'm gonna bring you here to August of 2022, right? We're in August this month. Okay, did you not contact Miss Dorsey, okay, by using a different telephone number to try to contact her in reference to getting back together and wanting to go out with her?
No.
Okay. And on the date of whatever your date you're saying something happened, June of this year, you never contact whatever you received by way of emails or text messages, you never contacted the police and made a police report that you felt threatened at any time. Isn't that true?
I have. Well,
Did you contact the police?
yes, and that was on that date.
Did you make a police report?
Yes.
Okay. And was anything done as a result of that police report? Did the police, to your knowledge, go out and contact my client, make an arrest? Did they do anything in reference to that?
I think we're here for that now.
I'm asking you, did they do anything at that time? You went to the police on that date. That was June. You just told us June the 29th. We're here at least several weeks later. Okay. Almost a month later. Okay.
Okay.
And the police did nothing after you contend that you reported this to them. The police took no action. Isn't that true?
It was more, I'm not too sure if the action that was taken or not.
That's fine. If you don't know, you don't know. That's perfectly
Yes, I don't
fine.
know.
Okay. And this, whatever you're talking about, as far as your vehicle is concerned, you never saw anybody do any damage to your vehicle. Isn't that true? Yes or no? Did you witness somebody? You witnessed somebody? Who did you witness?
I didn't witness anything with my eyes, no.
Okay, that's my question. And also, you have a problem with other people. You hang out with gang members. Isn't that true?
Objection, Your Honor.
No, I
Objection,
do not.
relevance.
I play video games in my room, my sir.
I got you. So you don't have any.
Just in response to that, Judge.
yeah. I don't know that I appreciate the characterization, but the question as to if there's a possibility of somebody else committing the damage is a valid question. So I will overrule the objection, but Mr. Todd, can we be more specific?
Yes, isn't it? Let me ask this. Isn't it true that prior to all this, your car was shot up at a hotel? Isn't that true?
Negative.
Your car's never been shot up at a hotel.
No.
Okay. On this occasion that you're referring to, that your car was damaged, you did not personally see anybody do any damage to your vehicle, correct?
No, just the ring cameras that was placed on the house.
Okay. Well, I mean, do you have a ring camera that shows who did the damage to the property?
I don't think it shows it accurately about who shows it, but I think it still has a good picture of them.
Okay. And just for clarification, during this period of time, and I'm referring to 2022, we're talking about this year, on numerous occasions, my client has allowed the child to visit with you and your mother at your mother's property, correct?
At what date? I'm sorry.
In 2022, we're here in this year, 2022.
Yeah, I think we watched him a couple of months this month or this year. Sorry.
Okay. You are aware that you're not supposed to be trying to contact Mrs. Dorsey. You're aware of that, right?
Correct.
And you have been over to her house on numerous occasions while this order was in place, correct?
I'm not too sure if I did or did not.
You don't know whether you went to her house? You don't know that?
No, due to me having to pick up my son. So there were some instances where I had to accompany my mom due to her aggressive behavior. So I had to bring a witness with me to be able to meet her at her house. So I don't know exactly the dates that I were over there, and as well as if they were inside her house, outside her house, or if she was just meeting me somewhere. So I don't know exactly the dates. So I would have to say I don't know.
You don't know. Isn't it true, and you've heard testimony from other witnesses, that you went into the house, had an argument with Mrs. Dorsey while her mother was there and the boyfriend? You recall that testimony?
Yes, and that testimony was dismissed due to the witness lying about what had happened on that day and or even relevance of being there.
Sir, the person testified. His testimony was not dismissed. He would testify in court.
Yes,
Okay,
yes,
correct? You remember that?
I remember his testimony, yes.
Okay. Remember him testifying that he told you to leave because you were loud, boisterous, and using profanity?
Oh, this is a different one. Okay.
You remember that?
I remember what he said, yes.
Okay. And told you to get out of the house, to leave the house because you were causing a disruption and a disrespect while you were at where Mariah Dorsey was living. She was living there at that day, on that date and time, correct?
I'd assume so, yes.
Okay. And at that point in time, on that day, you actually took her phone. Isn't that true?
No, Your Honor.
Okay,
I mean, no. So I don't know why I said that.
that's fine. And isn't it true that you contacted one of her friends, Mrs. Rump, in reference to attempting to get back with Mrs. Dorsey? You had contacted her because you know she was one of her friends, and you contacted her in order to try to get back in touch with Mrs. Dorsey. Isn't that true?
No, I think all of them had contacted me via Instagram trying to follow my private account. I didn't accept. I messaged them due to wondering the relevance of trying to follow me. And all of them were more or less nice and or blocked me from me asking.
Yeah. Isn't it true that Miss Dorsey had blocked you from her texting? Isn't that true?
I don't know because I do not text her.
Oh, okay. When do you say the last time you text her?
That would have to be that day of me getting threatened.
So that would have been back in January.
Well, like, yeah,
January.
January, I think it was the 29th. I think that was the last day. I think she started at the 27th and it ended on the 29th, and then 3 days later, the car.
Okay. And are you talking about what year and what month?
Say that again?
What year are you referring to? What month and year are you referring to?
January, right?
January. No,
It was the text messages. January, I think. June.
June of what year?
This year.
So that's the last time you text Mrs. Dorsey.
Yeah, because I was being threatened and asked to pick up the son.
So you contacted her.
No, she contacted me and I responded because I wanted to pick up my son. So to make sure of my son's safety, I responded back to meet at a police station. So I asked her to meet at a police station. She said no multiple times. Then we continued to ask for money for me to meet her. I denied. She kept saying she threatened you have 3 days to come pick him up. If you don't pick him up.
I want to object to the,
Okay.
he's not answering the question. He's just going off on a tangent. We're trying to repeat himself.
Sorry.
My question was very simple. When is the last time you text Mrs. Dorsey? Very simple.
The
That's
29th
the
of
question,
June.
Mr. Jimenez. I don't need to know the whole content of why you texted her. The
Yes,
question was
June-
asked as to when.
June 29th. I think that was the last day.
Okay, and that's the day you're stating that this alleged message you got from her, I guess, from some text message where you said you felt threatened. And then you also said that, yet there was on the message that you did a lot of sexual talk is what you said. What kind of sexual
No.
talk? Wait a minute, let me finish my question.
Yes.
What kind of sexual talks did you have with Mrs. Dorsey on that day?
I didn't have any sexual talks. It was her trying to get me to come over there to have sex with her.
Okay, so now you're telling us that she contacted you, threatened you, you felt threatened, but yet she was contacting you to come over to her house and have sex.
Exactly. Exactly.
Okay. Isn't it true that you put fake photographs on the internet of Mrs. Dorsey?
No, everything was from her and her my camera roll and or sent from her.
Okay.
And I don't post her at all. I don't think I've ever posted her a day in my life.
And just so we're clear, as far as at some point in time in 2021, you had asked Mrs. Dorsey to marry you. Isn't that true?
I don't recall.
Okay.
Mr. Todd, can you focus on whether it was before or after the bond condition? Because I'm only interested in what happens after the bond condition was imposed.
Okay. Then after the bond condition was imposed, did you not in fact contact Mrs. Rump in reference to locating Mrs. Dorsey and finding out where she was staying and what she was doing? Did you contact this witness?
I didn't hear you that good on the question.
Okay, I'm talking about after the bond condition was imposed. Did you contact Mrs. Rump? You know who she is, correct?
Yes, I think. I don't know names. I just know faces.
Okay, that's one of her friends.
Okay.
Okay. And did you not contact her after the bond conditions in an attempt to get in touch with Mrs. Dorsey to get back with her after these bond conditions were imposed?
No, the only time that was messaged, I think, to the one friend that you're mentioning was via Instagram, and that's because they reached out on Instagram to follow.
Okay. Just 1 minute, Judge. Mr. Jimenez, now after the bond condition, isn't it true that you went over to Mrs. Dorsey's house and you guys had sex?
I don't recall.
Okay. Do you recall me showing you the picture where you had your hand around her neck, choking her after the bond conditions were in place?
Objection, Your Honor. Mischaracterization.
Answer the question, overrule.
No.
Sir, do you remember the video that we played of you vaping at her house after the bond conditions? You're under oath, sir. I'm just to remind you,
Yeah,
because we've got
sure.
we've got you testifying in court, and I'm going to bring this to the court's attention. So I'm just letting you know that we went through a whole trial on this.
Yes.
So I just want to make sure it's clear. My question to you is, after these bond conditions were imposed in January, my question to you, isn't it true that you were at her house after that time and you guys had sex at her house?
I don't know because I don't remember that day. And I feel like if anything, if had sex would be before the bond condition.
Okay. My second question is this: did you not observe the video that was played showing you with your hand around her neck after these bond conditions were imposed?
I do remember the video, but I don't remember that date.
Okay. Isn't it also true that you threatened to kill yourself if my client, Mrs. Dorsey, did not speak with you after the bond conditions were put in place?
Wrong.
You didn't? Did you previously testify under oath that you threatened to commit suicide?
I testified that it was before the bond condition.
Okay,
Correct.
so it's your testimony, you're saying it's before the bond condition, not after the
was-
bond condition.
It was whenever I went to China, so that was whenever I went to go, whenever she met me to meet my son at a gas station before I went to China.
Correct,
Yeah.
and you went to China in January after the bond conditions. This all thing happened back in January. In February, the end of January, February is when you went to China for 10 days or 2 weeks. Isn't that correct?
Yeah, about 2 weeks.
So the bond conditions were in place at that time, okay? And at that point in time, you had contact with my client after the bond conditions were in place. Right before you went to China, you had contact with her because she allowed you and your mother to visit or have the child stay at your house for several days, maybe a couple weeks during that period of time, correct?
Yes, a month, yes.
Okay,
I wasn't there.
okay.
So she did stay, my son did stay with my mom as I was in China. She did reach out and I did threaten to kill myself due to the volume of disrespectful and utterly disrespecting, disgusting stuff that she was just calling me and talking to me. So yes, I did. And I was in a hotel room for 2 weeks. So all I could do was talk to her when she would just destroy my ego.
Okay, so you spoke with her while you were in China and this court order was in effect. You spoke with her at that time, correct?
Yes, as she reached out, yes.
Okay. Okay, sir, I'm going to show you what I'm going to have marked defendant's exhibit number 1. Okay? And I'm going to show this to you, this photograph. Okay, can you see that? Let me get it over here.
You have video. Show a video.
Okay, can you see that photograph I showed you?
That's a video. They had that show.
Mr.
Mr.
Hester,
Menez, is this a photograph of when a picture of you and Mrs. Dorsey in that photograph?
It seems to be.
Okay, and isn't that place where this photograph is taken at her house?
It looks like it.
And isn't it showing the picture? Can you see where you got your hand choking her around her throat? Can you see that?
I do not. I don't know if it's on her chin or what it is, but yeah, okay.
All right, and this is after the bond order in this case. This is in November of 2021. This is like 10 months or 12 months after the bond conditions were put in place. You see that?
Your Honor, objection. One, the relevance, and two, the foundation. This has been published, but it has been a foundation. That one has been even tendered, but it hasn't been a foundation for it to come in the first place.
sustained as to foundation, overruled as to relevance.
Okay. Isn't that a picture in reference to you having your hand around her neck?
Well, Mr. Todd, did you hear the court's ruling about foundation?
No, Judge, I did not. I'm sorry.
I said I sustained it as the objection as to foundation, as there being a lack of foundation, but I overruled it as to relevance.
Oh, okay. Well, let me ask you this, sir. That's you in the picture, isn't it?
I think so, yes.
And that's Mrs. Dorsey in the picture, isn't it?
Correct.
And that particular place is at her house, correct?
It looks like it if she didn't change the room.
Okay. And what were you doing over at her house on that occasion?
You know, the state will still, the state will still renew its objection in that one of the witness never positively identified himself, nor did he identify Ms. Dorsey. He said he believed that's him, he believed that, or he believed that's his house. And so the line of questioning would be inappropriate since seeing that he never positively identified himself. The picture, what's showing on the video is really grainy. And so it's hard to even make out what's happening in the thing for identification purposes in the first place.
Okay, overruled, but overruled based on the fact that they've discussed this event based on his testimony in the previous hearing. So they've already talked about this. So the court's going to overrule the objection. All right, so here's the thing. Let me just put y'all in the mind of where I am. I'm hearing testimony regarding threats, but I'm also hearing testimony regarding contact after the imposition of a no contact bond. And I don't know that we need to go further down this road of the back and forth between two very immature young people who share a child, poor baby. But what I need to know is what was the nature of the contact between the parties after the no contact provision? Because, and this is where my mind is, and I just want to direct whatever goes on next on either side. While there is an absolute no contact provision imposed by Ms. Dorsey, and there isn't one imposed upon Mr. Jimenez, if the alleged victim in a case contacts the person who is the defendant in the case, then the court has to look at, from a fundamental fairness standpoint, whether I can jail the defendant when the alleged victim has engaged in repeated contact over the course of a long period of time with the person that they allege has done them harm, and which the court has said this person needs to stay away from you. But there's been back and forth mutual contact. And so just so you know, I've seen enough on both sides, testimony from both sides at this point, to show that while, yeah, there was contact from Ms. Dorsey to Mr. Jimenez seemed to engage in just as much contact or more with Ms. Dorsey. So if y'all want to wrap this up, this is where I am right now.
Well, Judge, I've only got cross-examination. Of course, I have other witnesses that will testify.
I got you, but I'm
So,
telling you where I am right now.
Well, I don't think we need to put any more up, but that's, we have other witnesses to corroborate all this. So,
I don't really need to redo the custody hearing. All I need to know is whether there was contact and who made the contact, and was it after the date of the no contact provision, and what was the nature of the contact. So, Mr. White, do you have anything else on behalf of Mr. Jimenez?
Your Honor, is Mr. Todd concluded his cross-examination?
Mr. Todd, do you have any more cross-examination of this witness?
no, Your Honor, I've concluded my cross-examination.
Okay.
Your
Any,
Honor,
any redirect, Mr. White?
I have one more, Your Honor.
Yes, Your Honor. Your Honor, I'm ready to start.
All right.
Mr. Jimenez, between January 7th of 2021, when the order came out, and today's date, August 25th of 2022, have you ever initiated contact with the defendant?
I have not.
Okay. And when she messaged you, were you trying to engage her, or just were you trying to respond to her?
More or less, depending on if she messages from one of her main numbers, I wouldn't know if it was her. So I respond regardless, trying to find out who it is. And what was the next question you asked?
That was good. And earlier on cross-examination, the opposing counsels asked you whether or not that you had contacted the defendant's friends Have you ever initiated contacts with the defendant's friends who get into contact with the defendant?
I have not.
And after the defendant's initiation of contact with you, have you, we said earlier that you contacted the police. In that instance, where you contacted the police because of the defendant, who initiated that conversation?
She initiated it.
Oh, what he did? He sent me pictures of my phone.
Miss Darcy, I can hear you.
Okay. And what police agency did you file a report against the defendant with?
I think Fayette County.
Fayette County?
And they sent it here, I think.
Okay.
So I go back.
And if I were to show you a copy of the police report filed in Fayette County, would you recognize it?
Yes.
Okay. What did I just hand you?
My statement for the Fayette Police Department incident.
Judge, we're going to object to him. There's not a proper foundation laid. Nobody, unless they got the police officer here that did the report, Judge, that would not be admissible in court. So we would object to number one, there's been no foundation laid in this case for him to testify from the document.
Mr. White,
Your Honor, I'm currently laying a foundation.
okay, let him continue. All right, go ahead, Mr. Wright.
Is that a police report or your statement?
A police report. I think she got my statement when I was there.
Okay. What is the date of that report?
Your Honor, we're going to object now. He's testifying from the report of things contained in the report without the report being introduced into evidence. The report is not in evidence. He can't testify.
Sustained.
Do you recall when you filed a police report?
Yes, I think it was the day of me getting the message from her.
Mhm.
It was the day of me getting the message from her. I think that was the 27th.
What 27th of what day and year? Month and year.
June of 2022, I think.
Okay. Okay. What led you to file this report?
Her saying that I have 3 days. She went on a, I guess I can only talk about what this is. She just kind of just messaging me and threatening me based on like her
Your
saying.
Honor, we're going to object to the characterization as threatening. There's been no threatening. He did testify that he received contact, but there's been no threatening in this case.
Your Honor, may I respond?
Oh, overruled.
You ask the question again, please.
Why did you file this report?
I filed the report because it was.
Judge, I'm going to object that it's been asked and answered at least 3 or 4 times. So if we
Okay,
want to-
so
we
he
want to
was in
rehash
the,
it.
he was in the midst of answering when you objected to the characterization of threatening. I said he could answer, so I'm gonna let him finish the answer and then we can move on.
I was scared because I didn't know what was going to happen after those 3 days. Honestly, that's it.
Your Honor, may I have a moment to confer with my co-counsel?
Okay,
Thank you, Your Honor. After you filed the police report, did you contact any other agency
Yes, I came here.
with the Solicitor General's office?
Correct.
At what point did you come here?
Not too sure if it was the day of or a day after.
The day after what? Day of or after what?
The day of or after me going to do the police report.
And why did you file that report?
The police report.
Yeah, so when you came to our office, what is the reason, the reason that you came to office, like that report? What was that report about?
Oh, it was basically due to what she was saying. Oh, I don't know if that was that. I don't know if that was after or before the incident though. It's been so much going on. I'm sorry.
This one too. All right. I'm showing you what's marked as State's Exhibit 2.
It was after. Okay.
Can you identify what State's Exhibit 2?
It is the affidavit and the
Objection, Your Honor. He's testifying from some documents that have not been introduced into evidence.
I'm laying the foundation currently, Your Honor.
Well, he's testifying from the inside the document, what's contained in it, not the basis for the laying the foundation
Honor,
for it.
If I may respond, he has not testified to a single detail of the document. He's merely identifying what the document
All
is.
right, stop. Mr. Todd, sustain. So I don't know that it's relevant, whatever you're about to introduce, because all I need to know is he made a report. He already testified that he felt threatened. So, and it's all around the same time. So I'm clear. I think we're beating the proverbial dead horse. And if you don't have anything else to add from because we don't have anything so far in testimony that he knows who damaged the vehicles. The ring camera was seemingly inconclusive, or I'd be looking at it. And so if this is all y'all have for June 27th through June 29th, then I don't need to keep hearing the same things over and over again.
Your Honor, I think the state was intended to offer this into evidence as a prior consistent statement. Opposing counsel challenged that the witness made these statements, but for the custody proceedings. And so the state was going to offer this as a consistent statement predating the proceedings.
All right, sustain. Well, he can't, I mean, at this point, if that's the case, all I need to know is that he came and made the report. I don't know that, I mean, and it was consistent with what he was saying. I don't need to go too deep into it because what I'm trying not to do is retry the custody case, because that's not what's important to me.
Yes, ma'am.
Okay. All right. Anything else for this witness, Mr. Todd?
Just
Or is-
one or 2 points of clarification. After the bond conditions were entered in this case, you text my client on February the 24th. This would have been a month after this incident happened, or maybe a little bit more than that. Did you not text her asking her that you wanted to be a family, you wanted to get together with her, and you wanted to be a family?
No, I do want that family, but not with the aggressive behavior that comes from her.
Okay, so Mr. Jimenez, it's too much.
Yes,
Let me
ma'am.
ask you the question. Did you text her on February 24th of 2021?
Not that I recall, no.
Okay.
Cool.
Okay. So you didn't text her about that. Then did you text her on that day or later that day, cussing her out? I'm not going to repeat all the vulgar language, but that you were telling her at that point that you hated her, that she pissed you off. Did you text her on that date later afterwards when she would not make contact with you? Did you not make these numerous profanities to her, text to her after the bond conditions were in place?
No.
Okay. And did you not say, I will also never stop wanting you, and in the later text on February the 24th after the bond conditions?
No.
Okay. Okay, I think that's all, Judge, that I've got.
All right. Does the state have anything else to present?
Just to close the statement, Your Honor.
All right.